Welcome back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas. Today I want to talk about something that's often misunderstood and unfortunately mishandled by many immigration offices, VAWA cases. Unlike other offices, when we take on a VAWA case, I don't just hand it off to a legal assistant or a paralegal and call it a day. These cases are fact-heavy, document-intensive, and deeply personal. They require careful attention, legal strategy, and emotional intelligence. That's why I personally monitor every VAWA case that comes through my office. And here's why that matters more than ever in 2025. Starting last month, USCIS changed the way they issue requests for evidences or RFEs for VAWA petitions. If you're filing a VAWA case this year, expect it to take approximately 44 months to process. That's nearly 4 years. But here's the real issue. If USCIS has a problem with your case, they will likely not notify you until around the 36th month. That's 3 years after you have already filed. If you didn't keep a copy of your petition, or if your case wasn't strong to begin with, you're going to have a hard time responding to that RFE. Now let's take a look at this RFE that we received just last week. This is the new format USCIS is using for issuing RFEs for VAWA cases. The first page looks familiar. It lists the petitioner's name and the due date, usually 87 days to respond. That part hasn't changed. But here's the major difference. Instead of explaining what is missing, immigration is now using a boilerplate checklist. They are simply checking off categories like alleged abuser status, qualifying relationship, shared residence. There is no explanation of what's wrong or what's missing. And here's the kicker. In many cases, they're asking for documents that were already submitted previously. This is a serious problem. If you filed your VAWA petition by yourself, or you hired someone without a deep knowledge or experience, you might be confused when you receive this type of RFE. You won't know whether to submit new evidence, resubmit old documents, or revise your declaration. If your case was legally sufficient, but immigration still flagged it, you'll be left guessing what they didn't like about your case. That's not just frustrating, it's dangerous. So here's my advice. If you filed a VAWA case and it's getting close to the 36th month mark and you haven't received a decision, hire an experienced attorney right now. Don't wait until the RFE arrives and you're scrambling for documents while juggling work, kids, or medical emergencies, or life in general. At my office, we don't just file and forget. We monitor, prepare, and anticipate. That's how we protect our clients. Have you or someone you know received one of these vague RFEs from USCIS? Drop a comment below and let us know what your experience was like. Your story may help someone else avoid a costly mistake. Thanks again for watching Winning Law. I'm attorney David Nguyen, and we hope that we have made immigration easier to understand.
At David Nguyen's Law Office, we are here to help you. We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the Law Office of David.